Welcome to our second panel of the day. I'm delighted to be joined here on stage by our next four outstanding panelists. I will introduce them briefly, say a few things about what we have in mind for this panel, and then kick things off. Tyler Ochoa is professor of law at Santa Clara University School of Law. David Nimmer is professor from practice at UCLA and of counsel to Irell and Manella LLP in Los Angeles, and of course, author of the Nimmer on Copyright treatise. Bob Browneyes is the Michael McEwen Professor of Intellectual Property Law and a faculty co-director of the G.W. Barnard Center for Law and Technology at the George Washington University Law School. And finally, Peter DeCola is Professor of Law at Northwestern's Pritzker School of Law and Director of the JD PhD program there. Our topic for this panel, which really takes off on some themes that we've started to develop already today, is the role of the author and the acquisition and duration of their rights. We've heard already from Shira and from Peter and Jessica and Jane about the author-centrism and its mixed results, I think, of the 1976 Act. And we, too, are inspired by the Barbara Ringer quote that Jane gave us earlier about the philosophical shift in the 1976 Act. I won't reread the whole thing that Jane put on the table. I'll just remind you of the conclusion. Register Ringer said, taken as a whole, these changes mark a break with the 200-year-old tradition that has identified copyright more closely with the publisher than with the author. Ringer was pro-author and optimistic about these changes and their potential impact on the position of authors. She wrote, all this points in a healthy direction. It can certainly be hoped that authors and their representatives will take full advantage of these provisions in business dealings and that the provisions will provide the basis for further reforms. Our panel will offer an opportunity to examine some of the features of the 76 Act that changed how authors' rights were triggered, transferred, and calculated, and to explore whether these changes in fact provided authors with the new advantages in their dealings with publishers and other players in the copyright system that Ringer predicted. Tyler Ochoa is going to get the conversation started by describing the changes to formalities and duration implemented by the 76 Act. Tyler, thank you.
As billed as advertised, I'm going to be talking about formalities and duration. And the first thing we can ask is, well, why do we have these formalities in the first place? And one answer is, in part, because we've always had them. Registration goes back to the practices of the Stationers' Company well before the Statute of Anne is even enacted in England. Deposit was a feature of the Statute of Anne, that in a condition of copyright protection, that you would deposit copies with certain libraries. Notice, the 1790 Act in the United States required notice, publication of notice in newspapers before you publish the work. And then the 1802 Act amendment says we're going to have notice on all published copies. So those formalities have always been a part of our copyright tradition. But we can ask, well, why? What functions are they serving? And when you conceive of copyright as a financial incentive, right, we're going to give you a copyright in order to encourage the creation and distribution of new works of authorship, then it strikes me that formalities make a certain amount of sense. Why would we bother giving you the copyright if you didn't need the incentive in order to create and publish? If you're willing to create and publish a work without the incentive of copyright, there's not much point in giving it to you. So in order for you to gain that incentive, you have to do something in order to claim that copyright was important to you. Right? If copyright was an important part of your incentive, you had to sort of affirmatively do something to claim the copyright. And that's, formalities fit in with that sort of utilitarian view of copyright. If you have a natural right view of copyright, as was prevalent in continental European thought, part of that disconnect between the US and the rest of the world, if you have a natural view of copyright, formalities don't make any sense. Because you say, well, you know, you have copyright just by virtue of being an author. You shouldn't have to jump through a bunch of hoops in order to claim it. So let's look at how the 1976 Act changed these things. So the role of formalities under the 1909 Act, you have to publish your work with proper copyright notice in order to be eligible for federal statutory copyright. We did have common law copyright from the time that a work was created, perhaps not as broad as federal statutory copyright, certainly wasn't nearly as commonly litigated. But you have to publish, and notice is required on all copies published anywhere in the United States. Right? And failure to affix proper notice would place the work in a public domain. So again, this is part of the notion of copyright as an incentive. If you don't need the incentive, you can just publish and your work goes into the public domain immediately. That benefits from wide distribution. If you need the incentive, you have to do something. So publish with notice. Deposit and registration were required before a lawsuit could be filed. This was a change in the 1909 Act. You had to deposit and register as a condition of copyright before. Now you don't have to do it immediately, but if you need to file a lawsuit, you're going to have to comply with those formalities. And of course, we've already heard quite a bit about the manufacturing clause, that books in English had to be manufactured from typeset and printed in the United States. Okay. How did the 1976 Act change these? And the answer is not as much as we think, right? We tend to think of January 1st, 1978, the effective date, as a big change, but a lot of that comes later. In the 1976 Act, notice is required on all copies published anywhere in the world. Right, so that's an expansion of the formality rather than a diminishment of the formality. Before, you only needed notice on copies published in the US. Now, when you publish your work anywhere in the world, you need a copyright notice. Part of that is because of the Universal Copyright Convention, that the copyright notice sort of substitutes for other formalities that we might need. But it is an expansion of the formalities. Now, failure to affix proper notice still placed your work in the public domain. We do have the cure provisions added in Section 405. So under certain circumstances, you could keep your work from going into the public domain. One of those is omission on a relatively small number of copies, but that had a corresponding effect in the 1909 Act. Section 21 of the 1909 Act, omission from of the notice from particular copy or copies wasn't always fatal. So that's just carrying that exception forward. The big change is if you registered within 5 years and then you made an effort to add the notice to all copies distributed after that, then you could keep the notice from putting your work in the public domain. But it's really relatively minor exception to what otherwise is still strong role of formalities. Deposit and registration are retained. Deposit and registration are retained. They are still a condition of when you wanted to file a lawsuit. Right, because deposit is mandatory deposit is decoupled from registration, but you had to deposit when you registered. So if you had to register before you file a lawsuit, you still have to deposit, and that's still true today. The manufacturing clause was designed to be gotten rid of, right? So they added a sunset provision. This is going to go away in 1982. That didn't actually happen until 1986, but at least they were like, okay, we need to get rid of this formality. So the manufacturing clause was scheduled to go away. But when you look at this, the changes weren't as great as you might think. We just haven't downplayed formalities as much as might be the case. To me, the biggest change, the biggest single change that is made in the 1976 Act is the duration of copyright. So under the 1909 Act, we have a fixed period of years from the date of first publication. Now, technically, you could register unpublished works, and if you registered an unpublished work, your copyright clock started ticking from that date. But from the date of first publication or the date of registration, you had a 28-year term. It could be renewed for an additional 28 years, but again, only if you took the step of claiming that renewal copyright. You had to have registered your work sometime during the first term, and then you had to register your renewal term within 1 year of the expiration of the first term. right? So you had a maximum total duration of 56 years, but most works didn't use that 56 years term. The vast majority of works expired after 28 years for failure to renew, right? And now the only good data we have on this is the 1959 study on this and the copyright revision study. They did some statistics, and it turns out only about 15% of works were renewed, which means 85% of works went into the public domain after a period of only 28 years. Now, it turns out that there were quite differential statistics among types of works. The two types of works that were very heavily renewed, musical works and motion pictures. About 2/3 to 3/4 of musical works and motion pictures were renewed, and so got the 56-year term. Books, it's about 7%, right? Only about 7% of books are renewed. So most books went into the public domain after 28 years. The 56-year provision was really most important for music and movies. And then some works would benefit from 56 years. So how do we change that in the 1976 Act? We go to the Byrne minimum of life plus 50 for most works. That's a huge change. It's a huge change in mindset, and it's a huge change in practice, right? Not only is everything automatically protected from the time it's fixed, again, we did have common law copyright before then, so maybe not a huge shift, but everything gets protected for a really long term. And the whole point of the two-term structure was after 28 years, you'd get your copyright back, and if it turned out it was unexpectedly valuable, you'd have a chance to renegotiate. That was defeated by the Fred Fisher music case in 1943, which necessitated termination. At some point during that really long term, maybe you can grab your copyright back. But it's a really long term. And we have not felt the full impact of that term. No works that received a life plus 50 term in 1978 have yet expired, right? Because we're at the 50th anniversary of the Copyright Act. It didn't come into effect until 1978. The only works that have expired that got a copyright for the first time under the 76 Act are the transitional works, the works that were created before 1976 but had not yet been published or registered. They get their automatic copyright on January 1st, 78. And if they were considerably older, and if they were not then published before the end of 2002, they've expired, right? So you have some works that have expired, but as far as new works created in 1978 or later, none of those copyrights have yet expired, and they won't expire for another 20 years as a result of copyright term extension. You also have the change to work made for hire. That's still measured from publication, 75 years from first publication, or 100 years from creation, whichever is shorter. For the pre-78 copyrights, we extended the renewal term, so that the renewal term is now 47 years, 28 plus 47, a maximum of 75 years of duration. But again, you still had to have the formality of renewal for those pre-78 works. And then the transitional works that had been created before 78 but not published or registered until after 78, they get the same term as the new works, subject to a statutory minimum. Right. And then, of course, much later, we have the Copyright Term Extension Act, which extends all of these by 20 years. Compare that to everything that's happened since the 1976 Act was enacted. And I think within 20 years of the 1976 Act, we have a whole lot of changes that really do make significant changes in downplaying formalities. So, of course, Section 305, everything runs to the end of the calendar year. That's administratively very convenient. So changes made since then. The manufacturing clause finally allowed to expire in 1986. The Berne Convention Implementation Act is a big change. Mandatory notice is eliminated March 1st, 1989. So we retained notice in the 76 Act. It's finally gone when we joined the Berne Convention. Registration is no longer required for foreign works. However, for all works The remedies of statutory damages and attorney's fees are still conditioned in Section 512. So that's still a formality. It certainly violates the spirit of the Berne Convention, even though because they are remedies that aren't required by Berne, it might not technically violate the Berne Convention, but it certainly violates the spirit to retain that registration as a formality for those remedies. The Visual Artists' Rights Act gives us something that's couched in the language of moral rights for the first time, but it retains a formality because it only applies to the single original or to a limited edition of 200 copies or fewer that are signed and consecutively numbered. Signed and consecutively numbered, a formality for the Visual Artists' Rights Act. Automatic renewal for works first published in '64 or later. So instead of most works go into the public domain after 28 years, now, 64 to 1977, all of those works are going to have a 95-year term without the necessity of renewal. You have copyright restoration, beginning with NAFTA, then the TRIPS agreement, and then finally the Uruguay Round Amendments Act. Copyright restoration, for the first time, taking works that had been in the public domain out of the public domain and putting them back under copyright. It only applies to works of foreign origin. We haven't done it for works of domestic origin. But copyright restoration is a huge change. Then the Copyright Term Extension Act of 1998. So you put all of those together, we've had a massive change, only some of which starts with the 1976 Act. Right? The change in duration to a life-based term starts in 1976, and I think it's the single biggest change the 76 Act makes. Formalities, we sort of set the table for a reduction of formalities that then gets accomplished over the next 20 years. And I will leave it there.
While David walks up, I have a segue, which is that while making duration based on the life of the author and longer seems like a pro-author move, it eliminated renewal, which was envisioned, as Tyler explained, as a chance for authors to get a second bite at the apple after transferring a copyright. But David's going to tell us how it actually worked in practice and how that was changed by the 76 Act and beyond. Thanks, David.
Thank you, Molly. Let me ask you to focus on the year 2054. I'm not going to ask you the tough question as to what our constitutional order will be or the status of political parties. I won't even ask you the hard copyright question, what will be the status of works of authorship in a world of artificial intelligence. I simply want to ask the straightforward question extrapolating from today. Which of today's music will be popular in 2054? In terms of the movies that just won the Academy Awards or that lost, which of them are going to retain interest? And of all the books you read over the past 10 years, which of them will continue to be remunerative? Well, the simple answer is we have no idea. And this is not a modern phenomenon. 'Twas ever thus. Going back to 1926, no one knew which movies and books and music would retain popularity in 1954. And because it's impossible for an author and a publisher to contract knowing whether this will be the hit or not, there's an imbalance there, which Congress wanted to redress by saying that authors can make a grant of their work and then they will come back into the kingdom. How did that work? Tyler explicated the 28-year initial term followed by a 28-year renewal term. 28 years results from the fact that 300 years ago, the Statute of Anne had a 14-year term plus a 14-year renewal. By 1909, it was a 28-year term. So the theory was that the author would be able to renew the work 28 years hence and hence benefit from it. Well, that was the theory. In practice, publishers said, you want to publish your work? Good. Make an assignment of the copyright. The author said, of course. Oh, and one more thing. We also want you to assign today the contingent interest that you will have 28 years from now. Not having any bargaining position, the author agreed. Well, the matter went to the U.S. Supreme Court in the case that's already been mentioned several times, Fisher versus Whitmark. In 1943, the question is, Should we honor Congress's intent and authors should be able to reclaim the copyright? No, said the court. Freedom of contract applies. You already signed an initial grant of that renewal term along with the initial term, and so you have nothing. Well, that was the practical effect, and as a result, the smart move for authors was to die. An author who made a grant in 1926 who had the foresight to die in 1945 would mean that the work in question in 1954 could be renewed by the author's surviving spouse and children. And the expectancy that was granted never came to pass. Well, of course, that led to a further arms race where publishers would get a contingent grant from the spouse and the children, and so the situation made very little sense. As a result, Congress retooled and said, we have to get rid of that unworkable scheme of recapture of renewal rights, and let's implement something inalienable, termination of transfer. It's going to be automatic. For new works, it came into effect 35 years after the grant, so a work created in 1980 could be terminated in 2015. For the old works that already had a 56-year term, as we saw, 19 years additionally was granted, and it's only fair that the author be able to terminate and reclaim those rights. Here's the language of the statute. Quote, termination may be effected notwithstanding any agreement to the contrary. Clearly, the purpose was to eliminate the Fred Fisher decision. Now, mind you, this goes against the baseline that we all have so ingrained of us of freedom of contract. But freedom of contract is not unlimited. I don't even need to cite the case of a hitman in a contract to murder someone. There's not going to be any specific performance that the court will order in that context. But even when something is not illegal, a contract may still be invalid. Two consenting adults can have sexual relations. A contract for sex is called prostitution, and that's a crime. It's fine for a constituent to contribute to a politician, and it's fine for a politician to make a vote. But a contract in exchange for $1 million, you'll vote yes on my bridge, is called a bribe, and that is illegal. Now, Congress did not go so far as to say that a contract against termination is a crime. It simply said it's invalid. Termination may be effected, notwithstanding any contract, any agreement to the contrary. This was part of a unified law to replace the 1909 Act. And I have to talk a little bit more about renewal rights under the 1909 Act, which we already heard about from Tyler. As to a solitary work, it was intended that the author would be able to renew it 28 years hence. But sometimes there were composite works. Let's take an encyclopedia that has 100 authors. In that context, as of 1909, Congress said the proprietor, the encyclopedist, should be able to renew it. Now, in 1909, there was not even protection for motion pictures, but later on, those fell into the same category. So how do we replicate that? Well, when the 1965 bill that we heard about so extensively and intensively this morning was formulated, it had the termination provision, and it also had to have an exception, something analogous to the composite works of the 1909 Act. And this came in the form of the work for hire doctrine. Works for hire are not subject to termination. They can be renewed. They can be continued in the possession of their proprietor. And there are two types of works for hire. One was works by employees. So if you imagine the old studio system where everyone came to work 9 to 5 and they wrote screenplays, okay, the motion picture studio would still own it. That could not be terminated. And another example was specially commissioned works, which we also heard about. Basically, this applies to works of multiple authorship. So if you have the following, Congress called it a specially commissioned work for hire, which would not be subject to termination. Encyclopedia, an atlas, an instructional test, test answers, book illustration, maps, bibliographies, movies and other audiovisual works, because those were works of collective authorship. not sound recordings, as we heard about because of the anomaly that this was put together in 1965, and sound recordings were not protected until 1971. But basically, works of solitary authorship would be subject to termination. Let's see how it worked out. Classic work of solitary authorship, Winnie the Pooh. So A.A. Milne made the grant to Stephen Schlesinger, a Broadway impresario. Schlesinger married, of course, a girl in the chorus line who had a daughter. And so the daughter ended up owning the copyright to Winnie the Pooh, which became the most lucrative property, even more so than Mickey Mouse. But the young Schlesinger faced the possibility of termination of transfer because that's what Congress had anticipated. Not wanting to suffer the defeasement of her rights, she brought her lawyers together, and an interesting state of affairs unfolded. A.A. Milne was dead by this time, so his termination right belonged to his only son, Christopher Robin Milne. The Schlesingers and Christopher Robin gathered in a room and said, you know what, we had an old grant. We're going to get rid of that grant, and we're going to have a new grant so it will not be subject to termination. And the vehicle we will use to do that is called a rescission and regrant. You're going to get rid of the old grant, and you're going to make a new grant all in one instrument. And because of that, it will not be subject to termination. Well, it fell to myself to be counsel of record for the Milnes and to argue this case before the Ninth Circuit. My proposition was very simple. Before they got into that room and did a rescission and regrant, this was subject to termination. And you know what Congress said? Termination may be effected notwithstanding any agreement to the contrary. That's what this rescission and regrant is. It's an agreement to the contrary. Well, judges have in their mind freedom of contract. And as we heard from Peter, there are few judges who know this area of law very well. Sadly, none of them gathered on the panel on that day. And so the first question to me was from Judge Wallace. Well, Christopher Robin Milne entered into a new agreement, quote, didn't he do very well by signing the contract? And my answer was, Congress could have made a statute that said termination may be effected notwithstanding any agreement to the contrary, except when people do well or very well. But that's not the statute. It is absolutely categorical. And so it so happens he did not do well. He actually did not make money from this. He took the position, gentlemen do not terminate their father's contracts, and I'm not going to take money for this. But that's beside the point. Even he had made money, termination may be effected. Okay, that seemed to work, and it elicited the second question. Oh, said Judge Wells to me, so you, quote, so you are saying that he had no authority to sign the contract. Okay, I wasn't saying anything about authority. He certainly did have authority. He had authority to come in under state law and sign a contract. But you know what? There's such a thing as the Supremacy Clause, which says that federal law is binding, and federal law says termination may be effected notwithstanding any agreement to the contrary, even when someone had authority to sign. That elicited the third question. Quote, you are suggesting that he would have been better represented by counsel. He was represented by counsel. I was not suggesting anything of the sort. I was simply trying to vindicate the proposition that termination may be effected notwithstanding any agreement to the contrary. Well, we lost that appeal. Freedom of contract prevailed. Fred Fisher was resurrected, and that was the result. Now, I heard the question from the audience, what should we do about termination? And so I will give a very concise answer now. All we need is two fundamental changes. First of all, the voluntary nature of termination and the fact you have to jump through so many hoops to get it done is an impediment that makes it practically impossible unless you have counsel who takes a great many steps, which we did take in the Milne case. So termination should become automatic, not something that is subject to the formality of a notification. And the second is that Congress should pass a new law that says termination may be effected notwithstanding any agreement to the contrary, and this time we really mean it. Happily, I have word that Congress is set to pass exactly that law in 2054. The courts will enforce it, and so the kingdom is at hand.
So the work for hire doctrine that David discussed a bit and that we've heard about earlier today is one way in which the 1976 Act determines not just the rights of authors, but who qualifies as an author. And Bob is going to share insights about other aspects of this question of who counts as an author and what impacts the 76 Act had on that. Thanks, Bob.
Well, thanks, Molly. And let me first express my gratitude to all the conference organizers here at UC Berkeley and at Columbia, including both the faculty involved and the student editors of the great Berkeley Technology Law Journal. It's a great privilege to be able to speak here, and even a greater privilege, I think, to gain the insights of the other wonderful participants in this conference. Yeah, so as Molly said, I'd like to talk about those occasions on which people arguably do the kind of creative work that we expect of authors, and yet are not recognized as authors. And I have to say that even that way of framing the issue owes something to Barbara Ringer's quote and the shift in perspective that she documented and also helped effectuate. So here I want to touch on a few doctrines I think have a particular impact on whether creative work gets recognized as authorship, and consider whether and how the 1976 Act had an impact in those areas. Obviously, maybe the most obvious doctrine under which creators are excluded from authorship is the work made for hire doctrine, but Jessica and to some extent David have already touched on that, so I'll just say that in that respect, as Jessica explained, the direction of the 76 Act is really complicated, right? And in some way we could say that the 76 Act could be read as somewhat author-friendly, but only in relationship to the instant and expense test that was developed after the work made for hire grand bargain was penned in 1965. So a very strange kind of sequence of events. So here I want to focus on three other doctrines that I think may be somewhat less obviously tied to recognition of creative work as authorship, although some people in the room will recognize them as central. And they are fixation, derivative work authorship, and joint or co-authorship. So let me start with fixation. Of course, the 1909 Act doesn't directly mention fixation because under that act it is publication and registration that are important boundary markers. However, both publication and registration imply fixation. So under the 1909 Act, publication requires the distribution of physical copies, so a work definitely needs to be fixed in the 1976 Act sense in order to be published and obtain federal copyright protection. Even more importantly, only certain types of embodiment in a copy count under the 1909 Act. So under the Supreme Court's 1908 decision in White-Smith versus Apollo, musical works have to be embodied in visible notation. A phonorecord doesn't count as a fixation of musical work. By extension, a literary work could not be fixed in a phonorecord either, nor could it be fixed in the soundtrack of an audiovisual work. And going even further afield, a choreographic work, right, couldn't be fixed in an audiovisual work either. I think that's then taken as a given in the 1909 Act, and the Copyright Office then adopts this framework for the deposit requirement for registration. So registration of a musical work or a choreographic work following the historical model of books has to be by means of visible notation, and the visible notation forms the boundaries of the registered work. If you only deposit a lead sheet with melody and lyrics, that's all that counts as the registered work. As one result, many composers who do not notate and who are in that sense musically illiterate, although they're great composers, right, end up never being recognized as authors of the musical works that they composed. That's certainly true in the blues and folk genres, right? Many blues and folk musicians came up with melodies and harmonies and lyrics, and we have phonographic evidence that they did, but they never notated those compositions, and as a result, they were not recognized under the 1909 Act as authors. Of course, if those musicians had understood copyright law and they had the resources to find someone to notate their compositions, they could have done that. But the legal barriers to obtaining copyright are often interwoven with exploitation and sometimes fraudulent exploitation. So many songs end up not being protected by copyright, and others are claimed by people who didn't actually compose them. So along comes the 76 Act, and Section 102 famously provides that works of authorship can be fixed in any tangible medium of expression now known or later developed. So under a narrow interpretation of that provision, that could just mean that musical and literary and choreographic works still need to be notated, but doesn't need to be on paper. It could be stored in magnetic tape or an optical disc or solid-state drive, whatever. But instead, that provision has been given a much broader interpretation. And I think an interpretation in some ways aligns with legislative history, although I don't think people fully contemplated its impact. So under the 1976 Act language, you no longer need notation to fix a literary, musical, or choreographic work. If I sing a song that I composed into a microphone connected to an audio recorder, I have copyright not just in a sound recording, but in a musical work. If I dance a dance that I've conceived of in front of a camera connected to a video recorder, I have copyright not just in an audiovisual work, but in a work of choreography. So I'm continuing with the example of music that ends up allowing more people to be authors of musical works, as the musical work no longer needs to be notated and published. Moreover, if it turns out that it's easier to pass sound recordings back and forth between collaborators and do multi-tracks and all that sort of stuff, then I think it also makes co-authorship easier. Obviously, as Peter will say a lot more about after me, legal protections alone can't create an optimal market for creators. It's still possible for composers to be exploited and not get their due. However, I find one trend that some of you know about to be interesting. Emma Perot, Peter to some extent, Glyn Lunny, and others have written about the fact that the average number of songwriters credited in top songs, and the Billboard Hit 100 list is a popular source for data sets, has grown over the past decades. Glyn Lunny calculates that the average number of composers on a Billboard Hit 100 song has more than doubled from 1.86 in 1963 to 4.65 in 2018. And then Emma Perot tracks the timing more precisely. She notes for decades, the average fluctuates between 1.5 and 2.5, and then it starts taking off in the 1980s and really accelerates in the 1990s and 2000s. So there are a lot of potential reasons for this increase. Emma Perot considers the possibilities that star performers are demanding credit for songs they didn't write, a practice that dates back at least as far as Al Jolson in the 1920s. That songwriters are being added to mitigate legal risks after prominent litigation like the Blurred Lines case may have been perceived to broaden infringement liability, and that the practice of sampling in rap and hip-hop music necessitated broader crediting, something Peter has investigated in some depth as well. Glyn Lunny suggests somewhat pessimistically that the growth of number of songwriters shows that each songwriter is becoming less productive, and you need more of them to write one song. So I want to suggest another more optimistic possibility. When I investigated pretty closely the development of one song in sound recording in particular back in 1949, a song called A Little Bird Told Me, it was clear that although a gentleman by the name of Harvey O. Brooks composed the very basic melody and lyrics of the song, a lot of collaboration went into the song as it was ultimately first recorded. The singer, Paula Watson, and 3 or 4 other musicians actually went over to Brooks's house, and together they worked out new lyrics for a call and response between Watson and backup singers. Wasn't in the original Brooks song, a new bass line, an arrangement for a backup band, a hummed introduction. In other words, the musical work as it appeared on the sound recording was far more collaborative. At that time, however, back in 1949, Brooks alone was credited as the author of the musical work, and copyright in the sound recording went to the record company, leaving nothing but session payments for the other collaborators. If that initial recording of A Little Bird Told Me had been produced today, I would like to think that there's a possibility that the others who contributed new lyrics, bass line, arrangement, hummed introduction, and so on, would have gotten some songwriting credit. Of course, to the extent that back in 1949, significant revenue was still being produced by sheet music sales, maybe we could say, well, Brooks wrote what was necessary for the publication of sheet music, so only he should be credited as author of the sheet music. But today, a vanishingly small percentage of music revenues, comes from the sale of sheet music. And so the musical work as embodied in the sound recording is the work that's most often relevant when considering musical work authorship. That's much more collaborative. And at least as I read anecdotally about the production of sound recordings in lots of genres of popular music today, that's how many of the sound recordings and the musical works embodying them are being produced. So the rise in number of authors being credited for musical works may not be a matter of less productive songwriters having to combine their forces to produce anything, or the overreaching of famous performers or sampling or whatever. Instead, it may be at least partly that more of the people who are actually making creative contributions to the musical work that's embodied in the sound recording are being recognized as authors, right? And at the same time that the musical work that's recognized is thicker in the sense that it includes more of the elements that make the recorded version a hit. Obviously, it would take a lot of empirical work to tease all these elements out, but I think the timing of the increase in number of writers is at least promising. So recall that Emma Perot documents that the numbers are stable until the 1980s and start to take off. It's, of course, in 1978 that the legal change takes effect. And shortly thereafter, a change in registration process starts to gather steam. Right? At first, even in 1978, most people, when they're registering musical works, are depositing notation. But for another article, I documented the change in form of deposit. And by the 1980s, 80% of musical work registration applications are being accompanied by phonorecord deposits and only 20% by notated music, right? So, maybe something of that, some optimistic story can be told. So all this talk of collaboration leads me to the other two topics I want to touch on, and those are the rules about copyright in unauthorized derivative works and rules about contributions of expression to works by what one might call non-dominant creators. So in both cases, there's no doubt that the creators of those works or parts of those works are doing exactly the sort of things that authors do. However, those creators are sometimes not recognized as authors. So let's start with derivative works, right? Section 103A of the 76 Act infamously provides that protection for a work employing pre-existing material in which copyright subsists does not extend to any part of the work in which such material has been used unlawfully. And then we've got 115B2, which provides that a musical arrangement made under a compulsory mechanical license shall not be subject to protection as a derivative work under this title, except with the express consent of the copyright owner. So in both cases, those statutory provisions seem to be denying copyright protection for creative work that, were it done by somebody else, namely someone who owned copyright in the underlying work or had their permission, would be exactly the kind of work in which copyright would inhere. Whether that refusal to recognize copyright and otherwise original work was a new fixture of the 1976 Act depends upon what we think the 1909 Act did, and there's some controversy about that. David's father, Melville, in the first edition of Nimmer on Copyright, says that there's a Section 6, which later became Section 7 of the 1909 Act, that it provided for the same kind of forfeiture, but without that little nuance of just the part of the work. And so, there we'd say, well, maybe the 76 Act is liberalizing that a little bit. The current edition of Nimmer on Copyright in Section 306 takes the position that the 1909 Act statute text was ambiguous and the decision's contradictory in the language of Section 306. And then Pam Samuelson and Jessica Silby, in an article published last year in Boston College Law Review, argue that the pertinent text in the 1909 Act did not provide for forfeiture of copyright in the new expression, right? So if the Samuelson and Silby position on 1909 is correct, then the 76 Act newly refused to recognize the creators of unauthorized derivative works as the authors, I should say the creators, right, as the authors of those parts of the works that use the underlying work unlawfully. And even if the 1909 Act is ambiguous, the 76 Act still resolved the ambiguity in favor of not recognizing as authorship otherwise qualifying creative work in the context of unauthorized use of another work. Pam and Jessica Silby have argued that the 103A forfeiture provision should be read extremely narrowly. I don't know whether that 103A can bear the full weight of that narrow reading, but I have a lot of sympathy for the policy arguments in favor of that position. So let me just talk a little bit, right, about collaboration and joint works. The most relevant 76 Act text here is definition of joint work in section 101. And as with works made for hire, right, all of the work is being done in the definitions. And it says the joint work is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. So it's pretty clear that that language was intended to legislatively overrule the cases interpreting the 1909 Act as allowing a music publisher who had bought the rights to a melody from a composer to combine it with lyrics written by someone else and make it into a joint work. That's the 12th Street Rag case. And so under the Section 101 definition, okay, the intent needs to be the intent of authors of parts of the work, not the intent of a third party like a publisher. However, in the copyright revision study on joint ownership of copyright, George Carey, the author of that study, then Deputy Registrar of Copyrights, makes a much broader comment. He says, quote, in considering the question of whether and how the present copyright law may be modified to resolve the types of problems that I have referred to above, one might start with the premise that it is desirable to reduce, as far as possible, the frequency of the occurrence of situations in which a given work can be said to be a joint work. So, wow, ouch, that's a sort of big policy judgment. Courts seem to have taken that comment to heart, right, with the zenith probably reached either by the Ninth Circuit's 2000 decision in Al Muhammad versus Lee, which I think is good law right here in the International House, or the Second Circuit's 2015 decision in 16 Casa Duze LLC versus Merkin. I would give the edge to the Casa Duze case. A number of scholars have done great writing about the resulting problem of granting a dominant or controlling co-creator sole authorship and ownership of a work that other creators were quite consciously and intentionally involved in creating, and denying any authorship of that co-created work on the part of the other creators involved. That, again, is denying authorship status to creative work that is the same work that authors do. And I feel like I'm going to leave someone out, maybe even someone in this room, but my initial list of those scholars would include Mary LaFrance's 2001 article, Authorship, Dominance, and the Captive Collaborator, Preserving the Rights of Joint Authors, Sham Balganesh's 2014 piece on unplanned co-authorship, the amicus briefs of Sham, Justin Hughes, Peter Manel, and David Nimmer in Garcia versus Google, and then most recently, the not quite published article by Jessica Littman called Authorship Nonsense. So as Jessica puts it, courts have adopted rules that minimize, reallocate, or erase the creative contributions of inconvenient collaborators. Oh, such a lovely phrase there. So, given this is a symposium about the 1976 Act, and not about judicially developed rules about co-authorship, right, the question is the 1976 Act to blame for what's happened there, or should we put the blame on the courts that are resisting something that is outlined in the 76 Act? And I think probably more of the blame is on judges than on that language in the 76 Act about joint authorship. But we can have further discussion about that in the discussion period. Thank you.
We're going to continue to understand how the 76 Act had an impact on creators, with even more focus on music and how the Act did or didn't anticipate the current economic landscape for music creation and distribution. Thanks to Peter.
Thanks, Molly. Thanks so much to Berkeley, to Molly, Pam, Peter, Richard Fisk, and all the volunteers and conference organizers. It's really an honor to be here, and especially an honor to have an opportunity to speak on this panel with Tyler, Bob, and David. So in my remarks, I'm going to ask a question Molly posed to us, inspired by Barbara Ringer's remarks, whether the changes of the 76 Act, in fact, provided authors with new advantages in their dealings with publishers and other players in the copyright system. And I want to address that in terms of market power, although first I'll say it was so interesting to me that Barbara Ringer said that, because my first thought I have to say was, wait, that was the goal? Oh, okay. So But of course, Register Perlmutter and Peter in their talks have explained, well, yeah, relative to the 1909 Act, lots of things were different and were pro-author, and of course, and it makes perfect sense now. And so I'm really grateful to them for highlighting that history for us and setting this up. So as Molly said, like Bob, I'm going to focus on music as an example, and my main argument is going to be that the copyright reforms of 1976 did not, but perhaps more importantly, could not provide authors with meaningful economic leverage in the face of what was about to happen economically. And here, Jessica has set me up by mentioning the word, the profound consolidation that's happened in these industries, and I'm going to emphasize that and talk about what those changes look like in the music industry. Okay, so first, though, I want to talk about, we're being invited here to evaluate a policy. So policy evaluation, very broadly speaking, requires two inputs. So an understanding of the goals of the policy and then data to measure the results. So I want to talk about both of those things. So the way Molly framed this panel is really useful because we can focus on the Copyright Act's goals with respect to authors. People differ, of course, about whether one thinks the Act's benefits for authors are an end in and of itself. Is that an end in itself? Or is it a means to an end to serve just the broader public? Or is it some of both? And I don't think we have to address that debate. I think we're all interested in what it did for authors, whether as a means or an end. But I would like to highlight another normative dimension on which the disagreement is often implicit. So the degree to which the Copyright Act serves authors is often framed in terms of whether it serves the superstar artists. And I can just tell you from having worked on music industry issues for, 25 years, at most conversations I have, people think I'm talking about Taylor Swift. They don't have a bell. In my head, what I'm thinking of, which maybe is a weird economist, is that I'm thinking of a bell curve, right? There's a whole distribution of musicians. We can talk about Taylor. There's a lot of interesting stuff to say about her and her business career, but she's not representative, and many of the things, as I'll talk about, I think I will mention later, there are things that she's been able to do in her career that the industry has literally made sure no one else will ever be able to do. So not a helpful, working example. Exactly, maybe helpful in terms of normatively what you'd like to see some artists be able to get, but not helpful. So what I'm saying here is normatively what I am going to be talking about. And some people in the room may reasonably disagree. Like, I don't care about that artist who can't make money. I guess is it unfair to imagine our friend Chris Buckafusco sitting here and saying, if they didn't get the market response, like, I don't care. Chris doesn't think poetry should exist either. Those are interesting views to try to defend. He's not here to do it. But what I'm thinking of is that people are like, well, if you can't make it in the market, you can. And I'll talk about how that is, of course, part of our system. But I think we need more than like 4 artists. So that's so if you can go with me there. Okay. So that's the normative part, is that normatively I'm going to care about the distribution. And then data-wise, it's so frustrating. So we used to have a bureau at the National Endowment for the Arts that measured musicians and other artists' labor outcomes. There were PhD economists who worked in that department. Thinking of Neil Alpert and Greg Wassel, they wrote a great report that I read because I wrote my thesis in college about multiple job holding, and they studied multiple job holding among artists and musicians, and then that department gradually was shut down in the wake of the budget cuts from the Newt Gingrich Congress of the mid 1990s. So that's not to say there haven't been great efforts by the Copyright Office, including having a chief economist, and great papers by Bob and others about the data that we have about the registration system and other aspects of the system. But what I'm talking about is like labor market data, like how are artists making a living, how are musicians making a living. And it would be so useful to have longitudinal data over the course of the internet era, and we just don't have that. I can talk, if you're curious about why it's hard to do that, I can talk more about that. But one thing I want to say about the data we have, I recently saw a presentation just 2 weeks ago at this great the Music Law Summit at Vanderbilt, where my friend Will Page, former chief economist from Spotify, presented all this really exciting, optimistic data about recorded revenue from recorded music going up, right? Bob, you remember, you were there with me. The curves are all going up. It's very exciting. There's more money being made. We've recovered from the file sharing dip as an industry. None of that data broke down how much of it was going to the creators. None of it. It was just that's just completely elided from that dispute. Now, I'm not saying Will doesn't care about creators. I think he does, but he doesn't have the data. Right? And we don't have the data. If Will doesn't have the data, we definitely don't have it. And so that makes this hard to do policy-wise. So what we're even doing policy-wise, just one thing I should say is that we're going on, well, as Jessica said, we're hearing from artists, and we have to decide whether to believe them and evaluate the anecdotes. And if you say, oh, well, that's a weak argument to rely on anecdotes, well, that is, to some extent, the best we have because of structural decisions we've made about whether we're going to collect this data and make it available. So that would be one thing I'll say, which is maybe a little off topic on the Copyright Act of 1976, except maybe you could imagine a system that said that in setting up the Copyright Office and having provisions that there, that you could think as part of legislative design to try to think about data and policy evaluation. Okay. Now, to get to my point about consolidation, so let me start, my view on the economics of copyright is that, in a nutshell, copyright is meant to allow some amount of market power for a differentiated product. It's not a full-on monopoly, of course. Writing one book doesn't make you a monopolist in the economic sense. You're working in a differentiated market. But the intention is for copyrighted works to be sold at some markup above marginal cost if the market demand is there. And as I said, we've always understood, and everyone seems to like, the idea that your rewards under the copyright system, as opposed to, say, a grants system, are based on the proportionality between market demand, your reward and market demand, that we like the system, that you make more money from your copyright if there's that market demand. But if you accept that thought, that market demand has always shaped exactly how big quantitatively the copyright reward will be, then I think you should go with me and look at this other implication, which is that market demand, the shape and the position of the demand curve, if you want to use the econo speak, those depend on the market structure. The market demand is going to be shaped by what's going on both in the structure of the market for copyright aggregation, record label, in my music example, record labels and music publishers. But it's now also shaped by the concentration among the people who actually deliver, the companies that deliver the content to music. And here we're talking about the music streamers. And in the US, there are 4 that have 97% market share. So that's a concentrated market, and that is what is new. So this is what I mean by structure, this degree of concentration. And as Jessica said, they've both changed significantly since 1976. We're down to 3 major publishers and 3 major record labels. I've been doing this long enough that I remember when there were 7 labels. Independence, now you hear a lot, especially from Spotify, about the independent sector's numbers, and I think those numbers about the independent sector being big and that they're giving more and more royalties to the independent sector, those numbers are often misleading because there are major distributed indies. There's this hybrid category in music, and so if for instance, if some artist has a vanity label that they could be that could be described as an indie when really it's distributed through the major system. And then I'd also add here, by concentration, I don't just mean their market share within music. I mean that the publishers and the major record labels are just parts of larger conglomerates. So some of you remember when Universal Music was owned by a French water company called Vivendi. Composers and songwriters are on the one hand, and recording artists on the other, they're facing these large entities when they're negotiating contracts, and that's the bargaining power that David alluded to. So, or the lack thereof. It's really now, if we evaluate, okay, what's going on with those contracts? It's pretty interesting that the music publishing contracts, we don't hear as much about how they have become more structurally exploitative, but on the recording contract side, over this period post-1976, we do see more and more acquisitive behavior. So I'm thinking of the shift about 20 to 25 years ago to what are called 360 deals, where the record labels, their verb of choice is participate in the revenue of the artist when they're engaged in other endeavors, such as selling a perfume or going on tour or selling T-shirts or things like that. So that's a new, that was a new innovation. And there are other loopholes. So I mentioned Taylor Swift. Taylor Swift famously re-recorded her albums and owned, in order to own her sound recording copyrights. All the record labels have moved to have a clause that where artists contractually agree not to do that anymore, right? She will be the last. She was the first to really successfully do it. She will be the last, probably, unless we change the system, unless we make that kind of contract the kind of contract that you can't make. So there's consolidation on the side of the copyright aggregators. We're familiar with that story. I think the biggest story, though, right now is the consolidation of what I like to call technological intermediaries, the entities that actually retail or deliver music. So in 1976, music retail had national chains, but it was not particularly consolidated. There were lots of mom and pop stores, and those chains were not part of the biggest companies in the world. I don't think Sam Goody was part of the biggest company in the world. Was Coconuts part of it? I don't think so. I don't think that it was like the Coconuts was brought to you by the equivalent of Google or whatever. I don't think the oil companies owned them or anything like that. They weren't big players like what we see now. The copyright owners set the prices for music, and there was a markup for the retailers, but they weren't big players, and that starts to change with consolidation, not just because of the internet, but also brick and mortar stores like Walmart becomes the biggest retailer of music in the mid-1990s, and many of you have heard me talk about that before. And Walmart used that market power to weigh in on both pricing and content. They pushed for more family-friendly content. And so economically, just to go back to my model of the markup, like the copyright owners aren't able to set the price just through the copyright owning record labels and music publishers don't set the price now. They're negotiating with a technological intermediary, and that continues through with the iTunes store. And so if you have in your head like an economic model of a copyright owner setting price, choosing the markup, I think that is obsolete, at least right now. Like that isn't what's happening. It's instead one oligopoly selling through another oligopoly. That's what we have in music. And so I think that is why Spotify, YouTube, Apple Music, and Amazon Music are under what I perceive to be increasing scrutiny and more discontent among musicians. So I think what I would say then, to bring that back to copyright, is that copyright can only deliver economic benefits based on the structure and institutional design of the markets that the authors have to sell into. The value of rights has always, of course, been mediated by the market. If there's no demand for your creative work, copyright isn't going to deliver you revenue. But I would argue that the structure of today's market is categorically different than the market of 1976. And Peter alluded to this earlier as well, as did Jessica. In the music industry, there are now twin oligopolies for individual creators to contend with. The technological intermediaries, the deliverers of music, are not music companies. I think it's really important to understand they may well be happy to sell music at a loss in order to retain users on their platforms and to harvest their data. And that's just that's a dimension of economic value that music publishers and record labels have never had. And I don't think the 76 Act was designed at all with that kind of business model in mind, as someone that would use music as a loss leader or as a way to convince people to give them their data. Of course, none of this means it's not worthwhile to have copyright, or that that the shift to individual rights wasn't worth doing to have the limited economic benefits that it does provide. That's not my argument at all. It's just that my argument is that the twin consolidation I've described changes the numbers in terms of how much income copyrights can provide. It limits the extent to which legal rights can deliver, quote, advantages in business dealings from what Barbara Ringer said. So I think it's interesting that Barbara Ringer also suggested, and here I'm quoting again, the provisions will provide the basis for further reforms. The kinds of reforms necessary to deal with the copyright owners and the technological intermediaries' market power, of course, go beyond copyright, and as Peter Manel said earlier, into antitrust law and regulation. I've been writing about other reforms that could conceivably be part of copyright, although they might be unfamiliar. They could also just be considered as reforms in separate areas. So I'm thinking about regulating the terms of contracts in line with what David talked to us about with termination of transfers. You could have more provisions that are mandatory rather than defaults. And that also pertains to the songwriting complexities that Bob just talked to us about, which that was really a fascinating set of examples of where musicians are sometimes disadvantaged. There is draft legislation in the previous Congress about allowing for sectoral bargaining for musicians against the music streaming companies. That is one thing to think about. You could think about creating authors' rights for access to the data pertaining to how their works have been exploited. You could think might be helpful to think about mandating transparent accounting practices, given that now the sources of revenue for the ultimate deliverers of music may not have anything to do with music. This could get increasingly complicated. So I just want to end with what I think is the biggest new hole in authors' rights. If I haven't convinced you that this is a problem, Spotify has a new policy as of December 2023 you may not know about, you may know about it. It's a policy change. They no longer pay royalties on tracks that achieve less than 1,000 streams in the preceding 12 months. So Register Perlmutter mentioned, like, this was a huge success to bring streaming into the copyright system. It was a big shift away from the file sharing era where musicians aren't getting any revenue from that. It looks like a market compromise. It seems like an improvement over the litigation-based aughts, the 2000s, the 2010s. The streaming era seems good. But now we see what happens. Spotify is copyright compliant, but having your music on Spotify means agreeing that less successful tracks don't receive any royalties at all. Your choice as an artist is to forgo roughly 30% of the US streaming market or be subject to this new policy. And then to bring it back to the data point, how are we supposed to figure out how many tracks are not getting paid out? How do we know what has happened to the copyright system because of Spotify's policy? I can tell you, I'm hoping to find out. Myself, I'm working on a project about that, but I don't expect it to be easy. The data are not readily, readily publicly available. So that you would need to understand what the consequences of this policy are. How many artists are affected, to what extent? We just don't know. So I will say, though, I'm not going to take Spotify's word for it. I think this shows the huge importance of concentration as we think about evaluating the Copyright Act's success and reforming copyright, and then maybe looking to other related areas of law going forward. Thanks so much.
We're going to talk amongst ourselves for a little bit. We have questions for each other, and we also have time reserved for questions from the audience. So gather your thoughts, because I'll be turning to you in just a minute. I'll start with one question, and then I know folks have some questions for each other. We've heard some sector-specific analysis, especially from Peter, about the music industry, and I'm curious whether people want to say or speculate anything about whether these observations are generalizable. I'm thinking about book publishing, about movie making. There's lots in the news about that particular market and its consolidation these days. So I'm curious whether these are other areas where maybe the promise of a pro-author Copyright Act have not come or have come to pass in light of different market structures.
Is this on? I don't know that I have a lot to say about market structures in all of the copyright industries. I do think that there's another aspect of generalizability, and that is, one, creative practices. So in my comments about fixation, right, it makes a great deal of difference, I think, in music, that now we've got the fixation of musical works in sound recordings, because there are a lot of musicians who are commercially successful who are not using notation, right? So it makes a great deal of difference when you move into that regime. Less difference in areas where the creative practices still typically involve notation as they always did, like literary works. It is true that Garrison Keillor registered his monologues on the Prairie Home Companion. He deposited phono records of those monologues, not notated records, and he probably didn't notate them, although, with his resources, he probably could have, and then commercialized those recordings. So there's a tiny example of notation or the difference in fixation sort of affecting one stream of registration and commercial exploitation, but it's not going to happen for most literary works, I don't think. And then in areas of derivative work rules and co-authorship rules, I think those are generally more broadly applicable. except that, as Jessica says in the article that I'm going to continue to commend to you, Authorship Nonsense, that's very dependent on traditions and on customs and practices in particular areas of creative endeavor. So she incredibly documents how in areas of sculpture and painting, theater, screenplays, comic book characters, that there are different embedded practices that have already kind of been independent of the rules on the books and may continue to be so. Other areas, I think, are affected more directly by, or would be, by changes in rules about both derivative work, copyright protection, and the status of co-authors.
I'd like to ask Peter a question taking off on a through line of what I was talking about earlier in terms of contracts not being able to defease copyright policy, and a conference that Pam and Peter organized here in Berkeley 30 years ago about our UCC Article 2B, in which I published an article in the California Law Review saying that Pro-CD versus Zeidenberg was wrong. In other words, a company should not be able to defeat the U.S. Supreme Court's Feist ruling that telephone listings are in the public domain by putting them in a shrink wrap and saying the whole world is now bound by my shrink wrap. The Taylor Swift example of record companies saying you may not engage in sound imitation is another defeasement of one of the rights that Congress has given. Because Congress has said when there's a sound recording, you, the owner, have the right to prevent sound recapture. You do not have the right to prevent sound imitation. It seems to me that these record companies are systematically trying to defease that right of the copyright owner, and I'd like to bring the same considerations to bear to defeat that effort.
Well, wow, just like yes and yes. I mean, I hate Pro-CD versus Zeidenberg. I have since I was in law school. I think it's wrong. And I agree with you that I mean, it's interesting. You have to, you have to sort of, you would have to, kind of elevate the negative space of 114B into like a right of the public. But I don't think that, I think that's, for scholars, that's, I think that's the right way to think about it. And you just have to convince the judges. But yeah, I agree. I mean, I think that's really interesting that maybe we already have the tools to deal with that one. Of course, part of what's going on, part of the reason we're not seeing like challenge after challenge, or why there wouldn't be a lot of opportunities to challenge that, is that the market conditions for Taylor Swift were such that she could, she has a relationship with her fans such that she could direct them to which version they should be streaming on Spotify and successfully do that. But, I think it's, I think that's very interesting.
And Bob, what do you want to do with the negative space in terms of the unauthorized derivative works?
I want to shrink it. Well, no, I mean, I guess. I think so.
Who owns it at the end of the day?
I think that
and who has
the owners of copyright in the underlying work still have a tremendous bargaining advantage over the authors of the derivative works, because any exploitation of the derivative work is going to include, a publication or a display of the underlying work, and so they can say no, like, unless you agree to my terms, nothing's going to happen with your derivative work.
Okay, but if it's an old work, then that old work could expire in the next 10 years, and the question is, if the person who created the unauthorized derivative work has rights in it, that could last for another 60 years in those derivative elements.
I mean, I'm not as worried about that as some people in this room might be in the derivative elements. That was new creativity that happened much later. It's kind of like saying, should we still have copyright in pick a modern work that's based on an old
West Side Story.
Yeah, should we still have copyright in West Side Story because Romeo and Juliet is no longer under copyright? Yes, of course we should. I mean, obviously there's going to be debates around the edges of when a tiny bit of creativity was added. Are we worried about that? And that's like L. Batlin and Son versus Snyder. Are we worried when somebody just changes a little bit on those Uncle Sam Banks? And we could adjust the originality threshold sort of accordingly to say, look, if you just change a little bit, no. But if you invested a lot in your derivative work creativity, then absolutely. I'm not worried that that Romeo and Juliet's no longer in the copyright.
In terms of the relationship between contract and copyright, this is an eternal theme. You know, should copyright preempt state law rights in contract, or is it simply a default provision that can be changed by private ordering? And to me, the most prominent examples are, the use of so-called end-user license agreements to defeat Section 117 rights of owners of computer programs and to defeat the first sale doctrine. It's the same problem as we have with Pro-CD and other things.
Peter, I know you had a question you wanted to put to the group.
I do have a question. So I've been looking at these recent proposed bills in the music space. So there's one called the Protect Working Musicians Act that would provide an antitrust exemption that would allow sectoral bargaining with the music streamers. And then there's the more controversial and more expansive Living Wage for Musicians Act, which in a nutshell puts a 50% tax on music streaming subscriptions and then creates a fund to pay out. But I don't want to talk about the substance of those bills and whether I don't know that either of them are, on the cusp of passing or anything like that. But the one thing I noticed about the structure and reading the text of just the proposed bills is that they do this interesting thing. They define, they have these long definition sections where they define the terms, the regulated entities in terms of how much revenue they have, and they have, they're all very specific to. They all sort of scream out, we live in a world with a consolidated market structure. This only applies to the big four streamers. It doesn't apply to to any independent entrants. I just wonder a little bit, to me that raised a question about how we're designing the code. The 76 Act is this combination of common law type provisions like 102, 103, 106, like the 107, the core of it, and then all these regulatory provisions as Peter talked about. As we know, so which mode is better for authors? Like which one, or is there a difference in how they end up being protective, or is there something, or is it neutral? Does it just depend always on how the details work out?
I mean, I think it just depends. But Tyler's comment earlier about we need not just copyright but antitrust. I think that this is trying to do antitrust through copyright, and maybe the judgment is, well, we can't actually get an antitrust thing passed, so we're going to smuggle it into copyright law. Maybe. I mean, maybe that is the second best solution that we have to live with.
I don't know. I mean, it seems to me. The problem is that authors are always going to be diffuse and are going to lack bargaining power compared with a consolidated industry, right? So they're probably going to lose under either system. We've certainly seen a proliferation of regulatory copyright. Most of the amendments passed since 1976 tend toward here's a negotiated agreement rather than sort of a general common law approach. In terms of termination rights or recapture of the copyright, authors are better off with a termination right compared to the Fred Fisher music situation, but definitely much worse off compared to the 1909 Act as written had it been interpreted differently in Fred Fisher music.
So the problem you note, Peter, first drew my attention when I was writing up the Digital Performance Right and Sound Recordings Act of 1995, because there are various provisions that says these contracts will only be valid if 20% of the contracts provide X and 23% provide Y, meaning it facially cannot even apply to one contract. And in theory, there could be one small record company, as Jessica pointed out, and that's not reality today. So I don't know empirically who's benefited from it, but certainly that's the direction copyright law has gone in.
Okay, it's perfect timing to open things up to audience questions. I think we have microphones available for you.
Peter, so earlier you were talking about the poverty of data that we have. So the Bureau of Labor Statistics has data on occupational outlook, and they have data for artists and musicians and writers in various categories, and they have data about earnings. And so I agree with you that that is pretty bare, although it is longitudinal, it's pretty bare. And I'd be very interested if you had a specific menu in mind of things that you actually want the government to collect that you think would make research more effective.
So thank you so much for that, Chris. So first, right, I should have mentioned the problem with the Bureau of Labor Statistics longitudinal data is that it's based, because they're doing a nationwide sample, they only actually talk, they're talking to like 20 musicians or something and then extrapolating out. And so the data are extremely noisy. And so mostly what that data has been used to do is if you want to measure peak to trough in the variation, you can spin a story one way or the other about employment going up or down based on random variation about whether they happen to catch 22 or 23 musicians, basically. So it's just really noisy and so not super useful. But the kind of data I'm talking about are things like, not to like, so 15 years ago, I did a study with Future Music Coalition, my old organization, about, which was a survey of how artists make revenue, and we were right at the beginning of the streaming era, and we really wanted to redo it. And it costs a fair amount of money to do it, though, because you have to get musicians to trust you and fill out this long survey about all the different, there are 42 different sources of revenue that we identified. We're getting them to check boxes about whether they get those, and then we're asking them to roughly, put their revenue into buckets: live performance versus sound recordings versus compositions versus teaching versus other things. And, that just takes a lot of time, and it took a lot of outreach effort. And so, we applied to get funding to redo the study and have that kind of data going forward, and everyone said, yeah, but what's the policy change? Like, what are you measuring? And so none of the grant funding organizations, privately or in the government, were willing to fund us again. So I would say that would have been nice to keep doing that survey every few years, that kind of data about what are the sources of revenue, because the relationship here, the market conditions, if you're concerned about creators' welfare, you have to pay attention to what's going on in the live music industry that's tied to copyright, and you really need the full picture. Like for instance, now we're going to have some remedy of some sort, hopefully, in the Live Nation case, and then that will be a change in the industry, and it would be great to know what happened in the wake of that change, and it would have been great to know what was happening before in more detailed ways. So that's what I'm talking about. Just those rough buckets of like how they're making their money would be great. And to my knowledge, no subsequent study to ours from 2011 has done it.
This is a question for Bob on who deserves the blame for the exclusion of inconvenient contributors. And I think that it's pretty squarely on the shoulders of judges, sorry. The statute says merging their contributions with the intent to merge their contributions into inseparable or interdependent whole. Well, it doesn't say the intent to merge their copyrightable contributions. No, it doesn't say with the intent to be co-authors, which is correct. The Second Circuit, and the Ninth Circuit's statement that you're not a co-author unless you're the mastermind is completely nonsensical, sorry. So I think we can agree that doctrinally this is wrong. But it does have the merit of getting rid of the inconvenient co-contributors. If you apply the statute as written, then how do you decide who is enough of a co-contributor to be considered a co-author? Exclude people who are only giving ideas, but, or maybe not, because if there's a real collaboration, as Judge Posner suggested, maybe you should be a co-author. So I'm just trying to figure out how you would ascertain who should be an author.
I do understand that, for the defense of judges, the judges are saying, wait a minute, you're writing an abstract rule. We actually have to apply it in real situations, and we have administrability issues. And we also have issues about deciding the share of ownership, right? And we're going to stick with the every co-author gets an equal share rule because we just don't feel like we're competent to decide otherwise, and that is really Al-Muhammad, right? Because if we were to grant Jeffrey Al-Muhammad an equal share, that it seems outrageous to us. Therefore, we need to find some doctrine under which he will not be deemed to be any co-author of the work. So I acknowledge that with unplanned co-authorship, as Sean put it, that we've got sort of gap-filling problems, and they do include problems of, is there some threshold under which you wouldn't want to consider co-authorship at all, just as we talked about a threshold for derivative work authorship, and then do we stick our fingers into the issue of unequal shares, or do we have some sort of presumption that says, look, if you didn't plan for it, this is how we're going to do it, and you should have planned. I mean, in some ways, Al-Muhammad versus Lee, is all about, and frankly, 16 Casaduzzi as well, is all about fixing up problems caused by the entities that had good legal, or should have had good legal advice, not doing things that they should have done. And another way to look at it is, wow, if Al-Muhammad came out the other way, that would be just a huge shot across the bow of motion picture companies. You've got to make sure that you've got work made for hire agreements for these people. So I don't know. That probably is not a sufficient answer to your question, but it's my attempt at a startup one.
Okay, but with Al-Muhammad, you could have said, okay, everybody in the credits is a co-author. Everyone else signed work made for hire agreements, so you get, one 10,000th share or 1 5,000th share. In 16 Casaduzzi versus Merkin, to say that the director of the movie isn't a co-author makes no sense, right? It's inadvertent joint authorship, but you can't have inadvertent or unplanned joint authorship under the Second Circuit's test. That's just crazy.
I think we have time for one more.
So it's mainly a question for Peter, but I think it relates to everybody. So I'm channeling Chris Butterfructo, which you brought in. So if we are saying that artists get less, we have several type of concern. One concern is that it's not fair. I want to put that aside for a second. The other concern is that we might not have creativity in the long run. And the question is, do we see that? I mean, this is going back to the basic principle of the simplified incentive story. So do we see that? Do we have the data? Don't we have the data? Is it coming around the corner? I know it takes time. So how do we think all of that affects creativity in the long run?
So really briefly, I'd say two things. So one is that I don't put fairness aside. So, unlike, so that's part of it. I'm freed from the shadow. I lost my economics card, you know what I mean? Like, whatever. I've been cast away from the discipline long since, so I'm not at any risk anymore for not being a utilitarian. But anyway, I still have the diploma, but I'm not sure. They may come and seize it someday. As far as the incentive, no, we don't. I mean, that's and that was the power of Joel Waldfogel's work to say in the streaming era, in an internet music era, we get like 3 times the number of releases and things like that. So no, we're not seeing any shortage of releases. But the effects that we're worried about are things that might be more subtle, career effects, things like that. And we. But no, I don't think that's I think it's more of a fairness argument. It's more about a divide. It's more. You're exactly right. You're perceiving it's more of a dividing the pie kind of argument, and then wondering about could that have long-term effects or not? I don't know. Yeah.
Please join me in thanking our panel.
Great.
Let me explain what's happening next. It is time for lunch. You are going to grab your lunch over the next 30 minutes, and then at 1:35 we will have our lunchtime or dessert time or coffee time keynote, and Judge McEwen's gotten lots of teasers for her view from the bench, and that's what we're going to get at 1:35, so please be back and ready for that.